Good morning, everyone. This is Freya Shantz, the hearing clerk. I just received an announcement from the hearing officer. We're going to start the hearings 5 minutes late this morning.
Good morning. This is the second regular docket of the Oil Conservation Division's cases. These are restricted to status conferences. We are here today on the 24th of April, 2025. It is 9:03 a.m. And I'm going to begin the docket with case number 25035, which is joined with 25037 and 25038. Entries of appearance, please.
Julia Brogy with Holland and Hart on behalf of the applicant, MRC Permian Company.
Thank you.
Good morning, Mr. Hearing Examiner. Darren Savage with Aberdeen Shill on behalf of Coterra Energy.
Coterra. Okay, thank you.
Good morning, Mr. Examiner. Miguel Suazo with Beatty and Wozniak appearing on behalf of XTO Energy for monitoring purposes only.
Good morning. I think those are all the parties we have. And Mr. Suazo, let's start with you. Did you object and withdraw your objection?
Correct.
Okay. All right. So we have a withdrawal of objection. Mr. Savage?
So we objected, and this is the second status conference from last time where we discussed the right of Coterra to develop the 1 mile unit under voluntary agreement.
Under voluntary agreement. Could you explain that a little bit more?
So this is a situation where Matador has proposed to pool the east half of section 3 and the east half of section 10. That's a stand-up unit. So Coterra owns 100% under JOA, or controls 100%, owns 97%, controls 100% under JOA in the east half of section 10. So instead of, there really is no need for a contested hearing if Coterra were to develop that unit, that 1 mile unit. So so I guess the status conference today is to discuss that matter.
Ms.
And-
Burgee?
Yeah, I agree with Mr. Savage. I think I can shed some light here. It does sound like as long as Mr. Savage can confirm on the record that they're not planning to develop the east half of section 3, then MRC will dismiss its applications in all these cases. But we just want confirmation on the record so that we don't have to, because I think there was some confusion about whether it was 1 mile or 2 mile. Is that right, Mr. Savage?
Yeah, Mr. Examiner, I would like to comment on this. I think that it would be important to have this on the record.
Before you do, let me look at the application that MRC Permian filed. They wanted an order approving a standard 800-acre, more or less overlapping horizontal well spacing unit in the Bone Spring, underlying the east half of sections 3 and 10, township so-and-so, and a pooling uncommitted interest owners. Okay, so we have that area there. Now, before you say anything, Mr. Savage, Ms. Burgee, why are there 3 cases?
Mr. Hearing Examiner, I'm not entirely sure, but I will say that one of the 3 applications is for the Bone Spring formation.
Okay.
And then the other 2 applications are for the Wolf Camp. And case 25037 is for the west half of the east half of those 2 sections. And then that final case, 25038, is for the east half of the east half, and again for the Wolf Camp. So I think that they're targeting slightly different areas.
Okay, I understand. And so, explain to me why, if Coterra says, explain to me why you're going to dismiss your cases.
Is that directed to MRC?
It is.
So I will concede, I am covering this because the other attorneys are out,
Right.
But my understanding here is that initially we had understood that I don't know if Mr. Savage's client is Cimarex or Coterra, but that party had proposed 2 mile wells, and we thought that it was going to develop into the east half of section 3. But since then, it is, I think Cimarex or Coterra have clarified that they're only seeking to develop section 10 with 1 mile wells. And as a result of that, it sounds like then we can both proceed accordingly, and therefore we can dismiss our applications.
So I think what you're saying is, as long as they confine their development to a certain area, we don't have to force pool anyone else. So there's no other interest. There's no other interest owners.
I'm not sure if there's no other interest owners or if we have commitment, but I'm going to defer a little bit to Mr. Savage here. But I think that is correct. There was just some confusion about different proposals or development proposals. And as long as they're only proceeding with 1 mile wells, then there's no issue and we can dismiss these applications.
Right. I understood that. I'm looking at your exhibits that were filed in this case. I'm looking for the one with the ownership interest. I think it's A4. Hold on, Mr. Savage. I just want to look at this before I ask you some questions. So, okay. But see, I'm looking at page 36 of 75. These are your exhibits, Ms. Burgee.
Yes.
And I'm seeing other people on here. So anyway, okay. So now that so Mr. Savage, go ahead, please.
So if I'm understanding MRC correctly, it sounds like they'll dismiss these applications for the 2.5 mile, and it sounds like they would do new applications for the 1 mile. And
I didn't understand that.
yes, I
That
think
was the
that's
part that was left out.
that would be I think the overall plan on that. Um, but so just to clarify, Mr. Hearing Examiner, so Katerra had to protect its right to develop the east half of Section 10 under the voluntary agreement and not risk losing that opportunity under a contested hearing. And there's no there's no reason to for Katerra to pool the east half. But this is very valuable property, and it needs to be protected. But this does not mean that Katerra is unwilling to continue good faith negotiations with Matador. Katerra has been in the process of negotiating some very important agreements involving these lands. And as I understand, the negotiation between the parties could result in significant mutual benefit for both Matador and Katerra. And Katerra had informed Matador from the outset of the negotiations that if they could not reach an agreement, that Katerra would develop the east half of Section 10 as a 1 mile unit. Therefore, there was no reason to burden the division with a contested hearing over this matter at all. And we just want to let Matador know that Katerra remains ready, willing, and able to work towards an agreement that it believes would significantly benefit both parties.
So, Ms. Burgee, this application I'm looking at in case number 35 seeks to pool the east half of 3 and 10. So I'm assuming 3 is north and 10 is south.
Yes, Mr. Hearing Examiner.
Yes, okay, that is how
Yeah.
it fits. Okay, so Mr. Savage, your client seeks to develop what, the west half of 3 and 10?
No, well, first of all, the development would be contingent upon negotiations with Matador following through on this agreement, just to make that clear. Okay, so we would, if negotiations fell through, we would pursue the development of the east half of Section 10, east half.
Oh, the east half of 10.
Yes.
So Ms. Burgee, I didn't understand the idea of the 1 miles and how that, I'm obviously missing information. The parties need to fill me in here. So Ms. Burgee, explain why if Katerra just uses 1 mile laterals, you would dismiss and refile?
So my understanding is that we will just be developing then the east half of Section 3. And initially at some point, and I apologize, I don't know at what point in the negotiations or the proposals, but we had understood that what Mr. Savage's client was proposing would actually go into the east half of Section 3. But now we understand that it will not be. And as long as they can confirm that they will not be going into Section 3, then there's no reason for any sort of contested hearing. And we will dismiss and refile accordingly.
So are you saying that you would dismiss all 3 applications, even in the Wolf Camp as well?
Yes, Mr. Hearing Examiner, yes.
As long as their development from Section 10 doesn't encroach on Section 3?
Yes.
So then why were applications filed to pool the east half of Section 10?
I mean, I have to confess, I don't know if they have revised their plans. I just know that at some point it looked like there was a conflict here. And then through discussions with the party, it sounds like there really isn't. And so as long as Mr. Savage can confirm that, then we don't need to have a contested hearing on this.
Okay. So Mr. Savage, do you know why Matador is trying to pool the east half of Section 10?
Well, these two parties have been involved in some very productive negotiations, and it had looked like, for as far as I understand, it's looking like that there might be a really mutually beneficial agreement to be reached here. So, so it looks like MRC as I don't know to you know, pursue, and as part of pursuing the negotiations, decided that they wanted to pull the east half of section 3 and 10 to bring, I don't know, perhaps Secotera to motivate, I guess, to motivate, because I mean, often a lot of times parties will pool, do a pooling hearing. I mean, they do a pooling application to try to motivate, certain forms of negotiations. I mean, that could be a possibility. Certainly, a 2.5 mile unit would be more economical than the 1.5 mile
I see.
unit. But there really was no need. The negotiations could have been pursued could be pursued independently of any application to the OCD, because
Right.
because there's really no contested hearing here. Because
But didn't you say, Mr. Savage, excuse me, didn't you say that you have a JOA to develop section 10?
there is a JOA in place, and it only covers the east half of section 10.
East half. Okay.
Yes.
And so since you have a JOA in place, are there other mineral interest owners in the east half of 10?
Under the JOA, there are.
There are. Okay. All right. Ms. Burgee, it seems that these applications are not ripe to do anything with at this point. I don't understand why they haven't been dismissed already, but I'd like you to file a motion to dismiss these 3 applications, and you can refile them. It's without prejudice, obviously, but it sounds like the parties are continuing to negotiate. These have been sitting here on our docket since the early part of December. It's too long at this point. I mean, either you're ready to move forward by affidavit, which you're not, because you have an objection, or you are ready for a contested hearing in the near future, and you're not from what I've heard. Do you have anything to say about that?
No, Mr. Hearing Examiner. I mean, I think that is accurate, that, we do not intend to proceed on these, because I think that they have reached an agreement between these 2 parties.
Okay.
I guess I do just want to, because I'm not sure if I missed it but was there confirmation that there won't
No.
be development of?
There
Okay,
wasn't,
no.
no.
I
There was
mean,
not, no.
may we get that, or is that, Mr. Savage, are you prepared to state that, or no?
Well, I don't understand, Mr. Hearing, I don't understand why she insists on this. It seems irrelevant and immaterial. I will say that Coterra has a JOA in place that's ripe for development at some point. And they are preserving their right to develop that. So they're open to negotiations with Matador. They believe that there could be a very mutually beneficial agreement to be reached. The opportunity is there. And if negotiations fall through, then they'll look at developing that east half of section 10.
The east half of section 10, not the east half of section 3.
East half of section 10 is what the JOA covers.
Okay, I think that we have agreement here. Okay, yeah, I think we have agreement here, in which case we will be dismissing the case. Maybe we need to talk offline, Mr. Savage and I, but I think that we will be dismissing the case.
So, Ms. Burgee, I know these are not your cases necessarily, but I'm ordering Matador to file a notice of dismissal for these 3 cases. I will follow that up with an order, and you're welcome to refile once you have everything straightened out with Coterra.
Okay, thank you.
And if you don't have everything straightened out with Coterra, then you're welcome to refile, and we'll have a contested hearing over, who knows, possibly competing applications or not. I don't know, but it just seems at this point you're not ready to move forward with these cases. Anything further?
Nothing further from MRC.
Thank you. Mr. Suazo?
No, Mr. Examiner.
Mrs. Swazo, I have a question for you. You originally objected, you withdrew your objection. Why did you withdraw your objection?
Because at the time that these applications were filed, we believe that we're trying to be pooled. And once we received confirmation that we were not trying to be pooled, or else the applications had been modified, I forget which one, we withdrew our objection once it was confirmed that we're no longer being pooled.
Because I think the original exhibits filed in January had you as a pooled party.
That's right.
Okay. All right. Because I saw that on the list of. Okay, very good. Mr. Savage, anything further?
None, thank you.
All right, thank you. All right, so we're off the record in these three cases. Let's move on to VF Petroleum 25193. Entries of appearance, please.
Good morning, Darren Savage with Ebony and Schill on behalf of VF Petroleum Incorporated.
Julia Brogy with Holland and Hart on behalf of Apache.
Okay.
Good morning, Jackie McLean, representing Permian Resources.
Thank you.
Good morning,
Good
Mr.
morning,
Examiner. Carrie Hatley, entering an appearance on behalf of Marathon Oil Permian, Concho Oil
Okay.
and Gas, and COG Operating.
Thank you.
Good morning, Jordan Kessler on behalf of EOG Resources monitoring this case.
Okay, thank you, Ms. Kessler. Ms. Hatley, did you enter an objection, or are you just entering an appearance now?
No objection, just
Okay.
monitoring. Thank you.
Okay, thank you. Ms. McLean, your status?
We have objected.
You have, okay. On what basis?
They just don't like the proposed development plan.
Well, are you gonna, is your client, Permian, are they gonna, file competing application?
No, it's my understanding that they're working on a deal right now and they have drafts circulated, but Permian Resources would like to keep the May 13th contested hearing date, and
Okay.
we will present witnesses in the case a deal is not reached by that day.
Thank you. And, Ms. Burgee, what's your status?
Mr. Hearing Examiner, we've reached an agreement with the applicant, and so we are withdrawing our objections.
Okay, great. Okay, so we just have Permian objecting to you, Mr. Savage, and we have a May 13 contested hearing set.
That's correct.
Is there anything you want to discuss?
No, we want to go forward with the contested hearing.
Miss McLean, I'd like to avoid a last minute withdrawal of objection because we have to pay a court reporter to come up to Santa Fe, and when would be a reasonable time to notify us if you do reach an agreement?
I guess, when do you have to pay the court reporter by?
Yeah, okay. Let's see. Why don't we say, let's see, May 13, let me see what day of the week May. Looks like the 13th is on a Tuesday. We would need to know by that Friday, the 9th, if you reach a deal.
Okay.
May 9, deal, deadline. Because Mr. Savage will have to file his pre-hearing statement and his exhibits by the let's see, 4 days before the 13th, whatever day that will be. I'm assuming that's at least by Wednesday of that week. And do you anticipate, you said you would have witnesses, but would you be filing exhibits as well?
Correct, yes.
Oh, you would?
Yes.
Okay. So you should know even before that Friday, but I'll give you, you never know with
You never know.
negotiations being
Yeah.
what they are. Okay.
I'll let the client know that is the deadline, and hopefully they can work things out.
Mr. Savage, anything further on this case?
I don't think so.
Okay.
No need for that.
Okay. Ms. McLean?
Nothing from Permian Resources.
All right, we're off the record in 25193. Let's move on to 25220, 25221. These are FAE 2 operating cases. Entries of appearance, please.
Yes, Jackie McLean on behalf of FAE2 Operating.
And Julia Brogy with Hahn and Hart on behalf of Oxy USA and Occidental Permian LP.
Okay, thank you. Are there any other parties that you know of, Ms. McLean?
I believe ConocoPhillips has entered but not objected.
You don't know who's representing ConocoPhillips, do you?
I'm sure Miss Hatley.
Oh,
Oh, there she is. She just popped on.
Yes, Carrie Hatley entering an appearance on behalf of ConocoPhillips. Thank you.
and monitoring.
Yes, please.
All right, very good. So, Ms. Burgee, Oxy objected?
Yes, my understanding is that the parties are very, very close to reaching an agreement, and so we would just request an additional status conference.
Okay. All right, and Ms. McLean?
That's my understanding as well, but FAE would like to set a contested hearing date at the end of July or early August so that, we do have that out there and things can go forward.
Okay, let me take a look at the case file here. The application was filed, in February. Okay, so it needs to move along then. What was this that was filed on the 8th of April? It looks, we don't have titles in our imaging system. Oh, exhibits. It looks like you filed exhibits?
Yes, because we were planning on going to hearing on this. We were going to have a special hearing on April 14th just for this matter. And then that Friday, like Thursday or Friday before, Oxy entered an appearance and objected to us proceeding by affidavit.
And we were going to have what, a hearing by affidavit on the 14th of April?
Correct.
Okay, all right. Okay, let's see. Ms. Chance, did you send me you probably did, so let me just look in my.
It's in the chat.
I thought it would be. Yes, there it is. You said there were going to be no May dates, but there are 2 of them in there.
No June dates.
What you said. Thank you. Okay, July 1st, Ms. McLean?
No. Um,
Okay, if not the 1st, how about the 15th?
No, we need, for client availability, we're looking at the end of July or beginning of August.
Then we can do the 29th then.
Of July? Okay, that works.
That works for you?
Yes.
And Ms. Burgee?
Yes, Mr. Herring, examiner, that works.
And that gives the parties plenty of time to finish up these or paper up this agreement. I think we should have another status conference before the before the contested hearing. What do you think, Ms. McLean?
Yes, I think perhaps a status conference at the end of June.
Okay. Ms. Chance, what's the date in June that we have our status conferences?
It's June 26th.
June 26th. So, Ms. McLean, it's up to you to move these cases to June 26th.
Okay.
All right. Anything else, Ms. Burgee?
No, nothing on behalf of Oxy.
Ms. Hatley?
No, thank you.
Ms. McLean?
That's it from us too.
Wonderful. All right, we're off the record in those 2 cases. Let's
Thank
move on
you.
to a, thank you. Let's move on to a Mewborn Oil case, 25228. Entries of appearance, please.
Julia Brogy with Holland and Hart on behalf of the applicant Mewburn Oil Company and also on behalf of MRC Permian Company.
Okay, thank you.
Jennifer Bradfute with Bradfute Sayer on behalf of PBEX Operations LLC.
Thank you.
And Carrie Hatley entering an appearance on behalf of COG Operating and ConocoPhillips Company.
Are you monitoring?
Monitoring only.
You are. Ms. Bradford, you must have objected.
Yes, that's correct.
All right. And what's the status of your objection now?
The objection remains. The parties have entered into negotiations and they have been productive negotiations. So I believe this case could reach resolution within a couple of weeks.
25228. Ms. Burgee, do you know when you filed 25228?
Let's see. It doesn't have a date on here.
I got it. It's February.
Yeah.
It's February 12th.
Okay. I
So
apologize.
February 12 means it's starting to get a little stale. It looks like you filed exhibits in this case. You had intended to proceed, I think, by
affidavit.
affidavit, which was jettisoned based on the objection. It looks like the objection. No, let me see. Ms. Bradford, when did you object? Do you remember?
Let me pull it up. It was definitely before the hearing was set, after they filed their exhibits. I had it pulled up. We filed our objection on March 7th.
Okay, March 7th. Now I have a question. I see a motion for consolidation, which I've never seen before. It was filed, yesterday. No wonder I
Yes.
haven't seen it yet.
Yeah.
All right. So you would like to combine 25228, which is the case I called, with 25301 and 25303, which I have not called. I don't know if they're on. No, I don't see them on today's docket. What is the reason for wanting to consolidate these three cases?
These are competing applications. So with the combination of 25301 and 25303, the acreage actually overlaps with the acreage in Newburn's case. We had proposal letters that were out at the time when Newburn's case would have originally gone to hearing. We have since filed our applications and provided notice. The applications are currently set for the May 8th docket.
Okay, I understand. Thank you. May 8th for well, they would be set for the May 8th for a hearing by affidavit, but since they're competing, I guess they won't be set for the May 8th. So, Ms. Chance, would you just administratively continue the May 8th here, 25308 and 25301 and 303 to the May 22nd docket, maybe?
Yes, that's right.
It is. Okay. So will you do that?
Yes, I will.
And since it's competing, I'm going to grant the motion for consolidation unless Ms. Burgee, you're going to make an argument against that.
No, Mr. Hearing Examiner.
All right. So Freya, will you also join the three cases together for the purposes of a hearing?
Yes.
All right. I'd like to get these cases set for a contested hearing. May would be too soon for you guys because at least I think it would be too soon, right, Ms. Bradford?
Yes, that's correct.
Okay. All right. So how about July 1st?
That would be fine, Mr. Examiner.
Yes,
Ms. Burgee?
I believe so. July 1st.
All right, we'll issue a pre-hearing order for July 1st for a contested hearing on these three cases. And as you say, the negotiations look good and most likely they'll all go away. If the negotiations are successful, would these cases be unopposed and proceed to a hearing by affidavit, or would they literally be dismissed?
Mr. Examiner, what the parties are currently negotiating is potentially dividing the acreage. So right now it essentially, so each would have a section. So there may be some amendments that need to be made to the applications, depending on what is finally agreed to.
Which would require renoticing. So then we're looking at dismissal, at least for your cases, they'd be dismissed and refiled under an amended application.
That I'm not sure about because we don't know the final findings. My party actually split them by east and west. So yeah.
Okay. Ms. Burgee, what would happen to your case if you reach an agreement?
I have to confess, I'm not certain because
Okay.
I don't actually know what's being discussed. I just know that there have been discussions and I think there is optimism on my client's side as well. My client being Newburn. Matador is just monitoring it, but yes.
I mean, for someone who doesn't know what's really going on between the parties, when you file a compulsory pooling application, I'm assuming that there's more than just one other ownership interest. Ms. Bradford, since you know your cases better, are you saying that that Mewborn is the only other interest you would have seek to force pool?
No, we would still
Ah,
need to pursue
you would.
pooling,
Okay.
to my
I
knowledge,
thought so.
yes.
All right. And Ms. Burgee, I won't ask you the same questions. I know it's not your case. Okay. Is there anything further from the parties on these? Well, I've only called one case on this case.
No, Mr. Hearing Examiner.
Okay.
No, Mr. Hearing Examiner, thank you.
Thank you very much. And thanks for bringing those new applications to my attention. Okay, let's go to Rockwood Energy. We have several cases on the docket: 25241, 42, 43, 44, 45, and 46. Entries of appearance, please.
Caitlin Locke, appearing for Rockwood Energy LP.
And good morning, Mr. Examiner. Dina Bennett from Model Sperling on behalf of Coterra Energy Operating.
Okay, all right, thank you. Ms. Luck, I know you entered an appearance recently. I know Mr. Savage originally filed these cases. Where did he get the OGRID number to file these cases?
That is a registered OGRID with the state land office, and it looks like there might have been some issues with the registration at the OCD, but now we have rectified that. But it was at all times a registered OGRID with the state. Yes, sir. And at all times it was a registered OGRID number with the state land office, but it's my understanding there might have just been a glitch in the system. And we worked with Rob Jackson yesterday morning to be sure that all of that is clarified in the OCD system.
Okay. So Rob Jackson made sure that OGRID number is valid now.
Yes, and we can send email verification that we're registered in the system.
Okay, excellent. All right. So Rockford, what is the full name of Rockford?
It's
Rockwood.
Excuse me, it's Rockwood Energy LP.
Okay. Is that an investment company?
I'm not sure exactly how to describe them. They are an oil and gas company. They do have both non-operated assets, and now they're seeking to be a full-time operator by these pooling applications here in New Mexico. I can provide further color on that at the actual hearing on this matter, but at this point in time, what we're here for before the division is a status conference, and I think the parties are in agreement to push this to a status conference later in May to give Coterra as the other working interest in the unit time to determine whether or not competing pooling applications would be filed.
Okay, Ms. Bennett?
Yes, thank you. As Ms. Luck mentioned, Coterra, I and Ms. Luck had a conversation yesterday, and Coterra does think that May 22nd status conference is the best approach here because it's premature to set a contested hearing for these cases at this time. These cases were just filed on, I believe, back in February, but the April 10th was the first hearing date that was requested. So this is the first status conference in these cases. And Ms. Luck was entered her appearance a couple of days ago in these matters. So we just haven't had time to really work through anything on these cases. And it's Coterra's hope is that Rockwood's cases will be dismissed.
Okay.
And so we would ask for a May 22nd status conference to allow the parties time to negotiate.
Okay. Ms. Luck, they're your cases. How do you want to proceed?
I'm in agreement with Ms. Bennett. We spoke yesterday, and that's how we would request to proceed with these cases at this time.
All right. These applications were filed February 28th. There was an objection entered by Ms. Bennett on April 2nd. I'm happy to hold another status conference on May 22nd, but it will be the final status conference, Ms. Luck. So if negotiations are not productive, be ready to agree on a contested hearing date. And let me give you the ones that I would have offered you today had you asked for one.
Okay, thank you.
Of course, I would have offered you either the July 1st or July 15th. So you can check with your client and see which of those dates works for your client and Ms. Bennett's clients, of course, too.
Yes, and we'll be ready to proceed on either one of those dates, depending on which works for the parties.
Okay. And Ms. Bennett, would you be, do you anticipate if negotiations don't proceed as you hope, are you going to file competing applications?
Yes, we would need to file competing applications. So I mean, I'm happy to think about July 1st and July 15th, but we would need to prepare. I'm not sure that Coterra has even prepared competing proposals yet.
Okay.
Given just, you know, in full transparency, there's been two things that have kept them from doing proposals. One is that they are under the impression that Rockwood is selling its interest to another party, and therefore these cases would be dismissed. So that has, kind of slowed down the need to prepare competing proposals, is this understanding that Rockwood is selling its interest. And then secondly, when Mr. Savage withdrew, I wasn't even sure what was going to be happening today at the status conference. And so, I just put these kind of on the back burner until Ms. Luck entered her appearance. So I don't have any information to give the division today about the status of proposal letters. So while July 1st and July 15th are available, that might not work given timing for proposal letters and competing applications.
Okay. Well, I'm going to throw those dates out there. I'll also propose a date in August so that the parties have that as well on the burner here. I'll also propose August 12th.
Thank you.
As a possible date, giving Coterra plenty of time to circulate proposals and file their applications with the proper notice. And I understand the position you're in, Ms. Bennett. So thank you for being transparent. And is it, correct me if I'm wrong, but Coterra purchased the assets of Cimarex, is that right?
Well, Coterra was formed by a merger several years ago. So Coterra purchased the assets of Avant and Franklin Mountain Energy most recently. That's what we've most recently been discussing. But Coterra was formed several years ago by a merger of a couple of companies, and I can't recall exactly which companies they were that merged and formed Coterra.
So Cimarex is a separate entity from Coterra.
It's a subsidiary of Coterra.
Subsidiary. Okay,
Mm-hmm.
Perfect. Thank you. All right.
Mm-hmm.
Anything further on these cases?
No, thank you. Nothing from me.
Perfect.
Nothing further from me. Thank you, Mr. Hearing Examiner.
All right, perfect. Thank you. We're off the record in those cases. I'm moving on now to Tap Rock Operating 25272.
Good morning, Mr. Examiner. Miguel Suazo with Beatty and Wozniak, appearing today on behalf of Tap Rock Operating Company.
Okay, thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Coterra Energy Operating.
Thank you.
Good morning, Mr. Examiner. Carrie Hatley entering an appearance on behalf of COG Operating.
Thank you. I feel like I guess that's all the parties that there are. Okay. Miss Bennett, did you object?
Yes, I did. So it looks like Tap Rock filed these applications on March 10th, requested an April 10th hearing, and I filed an objection on March 27th. So today is the first status conference for these cases, or for this case, and Coterra is considering or is preparing competing proposals that it hopes to send out next week or the week after next. And after the competing proposals are sent out, we would need to wait the 30 days to submit an application for hearing. So there will be contested or competing applications that I will be filing.
Okay. Mr. Suazo?
Mr. Examiner, I think there's some concern here. I think primarily it's the lack of communication from Coterra. And Tap Rock has a drilling schedule. They're scheduled to spud in September. And so we'd like to set a hearing date as soon as possible. This is the first I hear that they intend to submit competing proposals, and they've had ample opportunity, to communicate with us. In fact, over the last year, they really haven't engaged with Tap Rock and initiated conflict. And in fact, the first that Tap Rock hears from them is typically in the form of an objection. So Tap Rock's ready to move forward. We don't want to take up any more time on your docket and for these things to go stale, especially because of the schedule. So I think that the soonest we can set a contested hearing after they they apparently are going to submit their applications, that'd be preferable for my client.
Ms. Bennett, based on the March 19 filing date, I'm presuming that your client received the proposals sometime in mid-February. Would that be accurate?
I don't have any information about when they received the proposals. I'm sorry. I mean, it would have had to have been based on the timing of the filing of the application, but I can't say for sure.
They actually should have received the proposals on February 1st, Mr. Examiner.
Okay. February 1st proposals. Okay. So Ms. Bennett, I understand that your client is, preparing competing proposals, and next week or so they're going to send them out, and that would mean about May 1st. So that would mean June 1st is when you'd file your application, and it couldn't be noticed for 20 days after that. Is that timeline accurate?
That's right. Yeah.
So, Mr. Suazo, it sounds like the earliest I could set this for a contested hearing would be in June. Do you disagree with that?
No, I think that's right. And I think if that's the earliest we can get it, we would love to be put on the docket for a contested hearing at the earliest available date.
We don't have any dates in June, according to the division hearing clerk. The first one after that would be July 1st, which would give the proper 30 days and 20 days, et cetera, from about a week from today. So does July 1st work with your client?
Unless there's not a special hearing date in June, we'll take July 1st if that's the earliest available.
Ms. Chance, do I have that right?
That's correct.
Mr. Suazo, I would look at late June, but the room downstairs is being used for rulemakings and other things that are going on that are outside of our control. So I think the July 1st is the earliest we could get this heard. Ms. Bennett, does that work for you?
That works for me, but I'll need to confirm with Coterra.
Sounds good. And Ms. Hatley, are you going to participate?
We are not. We're just monitoring this case.
All right. Okay. Is there anything further, Mr. Suazo?
No, Mr. Examiner.
Ms. Bennett?
No, I keep muting myself, so there's I have to unmute myself, but no, nothing else.
All right, thank you. We'll issue a
Thank you.
pre-hearing order for a July 1st contested hearing in person in Pecos Hall. All right, we're off the record in this case. Let's move on to a Mewbourne Oil case 25273.
Mr. Examiner, Jim Bruce representing the applicant. The applicant is actually Burnett Oil Company.
Burnett, thank you.
Good morning, Mr. Examiner. Miguel Suazo with Beatty and Wozniak representing Riley Permian Operating.
Riley, thank you. Did you object? Oh, I'm sorry, Ms. McLean. Hold on one second. Mr. Suazo, did you object?
Yes, we did object. And my understanding is that there's an issue concerning the size of the spacing. Once we get that resolved, we're hopeful that we'll be able to withdraw our objection, but that has not yet happened. So I think that's the extent of my knowledge on the communications between the parties as of today.
So when you say that there's a, can you explain what you mean by the size of the spacing?
Sure. So I think that my client prefers there to be 320 acre size units. And I'm not sure what the other side is proposing, but that's the latest detail I have in my notes. They told me that they thought they were going to work something out, but I have not received confirmation of that as of this morning.
Okay. All right. Ms. McLean?
Yeah, sorry. I don't know what happened to my camera, but now it is no longer. Jackie McLean representing Spur Energy Partners, and we are just monitoring this case.
Perfect. Thank you, Ms. McLean. All right. Mr. Bruce, do you know anything about this 320 acre spacing issue?
Well, that's the first I heard of it. Mr. Examiner, this case seeks to create a 640-acre one-section non-standard spacing unit and force pool the interest in that unit. And I was told by my client that Riley Permian signed a JOA for that. And then they, after signing the JOA, they subsequently filed the objection. I guess they want a 320-acre unit rather than a 640-acre unit. And the parties are in discussions, and my client would like to work things out with Riley Permian. But I'm inclined that if they're not moving forward quickly, I would file a motion to dismiss Riley Permian's objection because they have no standing to object because they've already joined in the wells.
Okay, thank you. Mr. Suazo?
I have not received a copy of the JOA, so that's news to me. I would need to confirm with my client. I'm not saying that that's inaccurate. I just have not received those details.
Okay, Mr. Suazo, when was this case filed?
It was filed on March 19th.
March 19th, okay. Mr. Bruce, how do you want to proceed?
I would like to set it for, well, my client would like to, this case has already been delayed a little bit. My client would like to move forward. I understand the division's hearing schedule issues, but get this put away as soon as possible.
Mr. Bruce, we don't have any hearing schedule issues. We have hearings available in May. It's just that we don't have a docket for June for special hearings. So do you want me to set it for a May date?
Oh, I would like that, yes.
We have May 13 or May 27, Mr. Bruce, which do you prefer?
Could I ask, I believe my landman is listening in, and if she could just simply tell me, because I don't know. I did not know the dates that were available.
Okay. And who is your land?
Yes, this is Christine Pilgrim from Burnett Oil Company.
Yes.
I think that we'd probably be okay with, we are in negotiations with Riley right now, and we hope to get it all straightened out here very shortly. So hopefully we can move on non-contested in the future. But I guess we could we do a status conference first and then plan a day? We're hoping to get this taken care of.
Why don't we do this? Why don't we set it for May 27? And
Okay.
Mr. Bruce, you could just file a motion if the parties agree and make an agreement that obviates the need for a contested hearing on May 27. And that's Ms. Pilgrim. We were asking if you were available on either of those May dates. So is May 27 an availability for you?
Yes, sir. That's great.
All right, so Mr. Bruce, what we'll do is we'll issue a pre-hearing order for May 27, and if you settle your dispute with Riley, just file a motion to dissolve the pre-hearing order, and then what we'll do is you'll have to move your case to the next hearing by affidavit docket.
Okay, thank you.
Which would be June the 5th.
Thank you.
All right. Anything further, Mr. Suazo?
No, Mr. Examiner.
Mr. Bruce?
No, sir.
All right. Thank you.
Thank you.
You're welcome. All right. Moving on to Permian Resource. This is 25283 and 84. Entry of appearance, please.
Yes, Jackie McLean on behalf of Permian Resources.
Thank you.
Julia Brogi on behalf of MRC Permian Company.
Thank you.
Carrie Hatley entering an appearance on behalf of COG Operating and Contra Oil and Gas.
Thank you.
Jordan Kessler on behalf of EOG Resources.
Okay, thank you. And I'm assuming Ms. Hatley and Ms. Kessler that you're monitoring.
Correct.
Okay.
That's a
I'm
great
getting-
assumption. You're
I'm
correct.
getting used to this now. Ms. Burgee, did you file an objection on behalf of your client?
Mr. Hearing Examiner, real quick, one more.
thank
Spin
you.
Holiday, appearing on behalf of Powderhorn EMP.
Powderhorn.
Yes, sir.
Did you object, sir?
No, sir, we're just monitoring this case.
Monitoring. Okay, very good. Ms. Burgee, back to you. Did you object?
Yes, we've objected.
Okay. On what basis?
So I knew you were going to ask me that, and I have to tell you, I'm not certain of the substance of the objection. But what I do know is that MRC has proposed different things to Permian, and I think it's maybe too soon to really evaluate whether they're going to reach an agreement on this. But they would like more time and opportunity to be able to reach some sort of resolution. So to the extent a hearing is going to be set today, they have asked to try to push it out as far as possible to allow time to do that.
All right. And Ms. Burgee, since you are not someone who participates regularly with this docket, it's my practice to leave it up to the applicant on how we want to proceed up to a point. So Ms. McLean, how do you want to proceed?
Yes, we have a different stance and would like to proceed to a hearing at the first available hearing date because Permian Resources does have a lease expiration that they're coming up against in their spacing unit. And it's my understanding that MRC hasn't actually sent out any well proposals or anything. And we do have an actual development plan in place. So we would like to proceed as quickly as possible to hearing on this matter.
Okay. Well, as you may have caught on, we have some dates in May and we have some dates in July. Which month do you want me to go over with?
What's the date? What are the dates in May?
The dates in May are the 13th and the 27th.
I just don't think we would be able to get stuff together in time for the 13th because exhibits would be due.
Sure.
You know, what could we do the 27th? It would be a great birthday celebration for us.
Well, and for me too, it'll be 2 days before mine, and I know yours is close to mine. Miss Burgee, what is it? Brogy or Burgee? I've been saying Burgee all this time.
I pronounce it Brogy.
Well, I by looking at what you put on the screen, it should be pronounced Brogy, and I don't know where I got Burgee from. I think I just heard Burgee, so I apologize all this time. All right, Miss Brogy, does May 27 work for you?
I don't have information on whether that, but I mean, if you're inclined to set it, I will bring it back to the to our client. My only concern that is in my head is I know that Adam Rankin is in that commission hearing, and I'm pretty sure that it resumes that week. Oh no, maybe it's the week before.
No, it'll be over by then.
Maybe it's the week before. Okay, that was the only reservation I had in my head. So if May 27th is the date, I will relay that information.
Sure, Mr. Rankin will be thrilled to go from the last week of that other hearing into another hearing, but
maybe we'll get a deal going.
Exactly. Exactly. Okay. All right. So anything from any other party? Okay.
Not from Permian Resources.
Got it. All right. Thank you. So we'll issue a pre-hearing order, May 27th, contested hearing. Thank you very much. We're off the record in that case. And actually those are two cases. That was 25283 and 84. So we have one less case on today's docket. It is 25288, and it looks like it's joined with 89, but I don't know what happened. 89 doesn't seem to be on our docket. I'm sure we'll figure out why. And of appearance, please.
Julia Brogy with Holland and Hart on behalf of Mewbourne Oil Company.
Thank you.
Jennifer Bradfute with Bradfute Sayer on behalf of Coterra Energy.
Thank you. Ms. Bradfute, did you object?
Yes, we did.
Okay. On what basis?
On the basis of we did not agree with Mewbourne's development plans, and we plan to submit competing proposals.
And I now see the note that Ms. Chance put in here that Coterra withdrew its objection for hearing by affidavit for 25289, which is on the May 8th docket, Ms. Brogy, in case you didn't know that. Now I know it too. Okay, so we're only dealing with one contested case. Ms. Brogy, how do you want to proceed?
My directions are to request a hearing as soon as possible on this one.
All right. So now I understand that Ms. Bradfute said that they're sending out competing proposals. Ms. Bradfute, any idea when they're sending those out?
I believe that they have been sent out. I definitely need to circle back. We're not ripe to file the applications quite yet, but I believe the notice letters are pending. The parties have been in negotiations, and Mewburn did send Coterra a counter proposal last night. It was unfortunately after business hours, so it's being evaluated this morning during the hearing.
Sounds good. Well, let's see. If let's say that the 30 days from now would be the end of May, 20 days. It looks like the earliest, Miss Brogy, that we could get this on our calendar would be the July 1st special hearing docket. It would be trailing at that point, but cases go away frequently. Does July 1 work for you and your client?
Yes, Mr. Hearing Examiner.
Okay, and Miss Bradfute?
I believe that should work, but I'd like to be able to confer with Coterra if that's okay.
Yeah, it's always, for those, the way I work it is if I set a date and it doesn't work for the parties, they'll submit a motion, explain with maybe an affidavit to back it up with some evidence to explain why that date doesn't work and propose another day.
That sounds good. Yes. Thank you, Mr. Hearing Examiner.
All right. We'll issue a pre-hearing order for July 1st contested hearing. Ms. Brogy, anything further?
No, thank you.
All right. Ms. Bradfute?
No, thank you.
All right. And that concludes our docket for today. And thank you very much.
Thank you.
Bye-bye.